My Lord, we come to the question as to whether the DFMA is or is not a contract for the supply of goods or services. It may be helpful to start by identifying what is a contract for the supply of goods or services, and it's not difficult to recognise such contracts. As the Court of Appeal said in paragraph 19 of the judgment, which you were taken to before the lunch agenda by my learned friend, contract for the supply of computer equipment, for other such supplies for use by the solicitor in the course of his or her practice is clearly a contract for the supply of goods or services. In this case, what the parties needed was an agreement, the DFMA, which regulated the way they behaved towards their lay clients so as to protect my clients' interests as lenders. It would have been perfectly possible for Impact to have lent the money to the lay clients in circumstances where there's a condition that the lay clients would use the money only to discharge disbursement funding. But in circumstances where the merits of the claim may not have justified either the taking on of the case under a CFA or the imposing of a liability for AT insurance upon the client, or in circumstances where the solicitors were not discharging their professional obligations to the lay client in other ways, such as taking the loan monies improperly, or themselves not discharging their duties to the lay client, then there was more likely to be a default under the loan. Clause 7.2, which my learned friend relies upon, was required in the event that if the clients defaulted or the loan was unenforceable, the solicitors would pay it. But the fact that there is such an obligation does not mean that the other clauses, 6.1 and 12.1 in particular, but all of the undertaking clauses, are not required for the scheme to work. What is fundamental to the scheme is that the solicitors should discharge their obligations under the conditional fee agreements, their obligations under the conditional fee agreement regulations, their obligations under the conditional fee agreement, their regulatory duties, because this is a highly regulated field, as we know from conditional fee agreement cases, and their duties to protect the lay client's exposure to adverse costs and indeed failure to recover own costs through after the event insurance or legal expenses insurance. All of those were essential to making the scheme work. And what the DFMA does is ensure that the parties comply with their respective duties towards the lay clients. And I therefore say that taken...
So what's the scheme? Fundamental to making the scheme work.
So the scheme is as follows. The Court of Appeal has set this out in the early part of their judgment, my Lord. I'll just recite it quickly. The lay clients arrive at Barrington through case management companies who provide clients. They are visited by an intermediary from the case management company, and the claim is supposed to be investigated at that stage to see if it's an appropriate claim for a conditional fee agreement. It is veracity that can be used for the purposes of matching up the case management clients with the solicitor. The solicitor must then decide if the case has sufficient merit to justify being pursued so as to protect the client's adverse costs and own disbursements liabilities with after-the-event insurance. Templeton were the after-the-event insurers, and there was another after-the-event insurers. And so as to justify committing the client to the loan. The idea was that if the case was successful, the loan would be repaid out of the damages, hence why the first call on the damages in the client account would be by my client's impact. But if the claim failed, the after-the-event insurance policy would pay the disbursements and therefore would refund the client for the disbursement liability and would therefore enable the client to repay the loan. How does the scheme go wrong? The scheme goes wrong, as His Honour Judge Waxman found in considerable detail in the liability judgment, because the solicitors failed at the outset to examine the cases, advise appropriately before committing the clients to the conditional fee agreements and the after-the-event insurance liability and the loans, and then acted in negligent ways thereafter. It may be helpful, my Lord, before I go to the DFMA, to take the court to this part of His Honour Judge Waxman's judgment, tab 6, at page 114, core pagination 118, electronic bundle. He describes the funding scheme at paragraph 5 onwards, and how the sign-up provisions worked. This is highly technical and detailed and highly regulated after the legal aid comes to an end. This scheme is effectively a replacement scheme. So paragraphs 5 through to 13, he describes what I have just provided my Lord with in summary. And then if I can pick this up at paragraph 14, he refers to the Templeton policy, which the after-the-event insurance policy, which requires that there are reasonable prospects of success. At 15, the conditional fee agreements were required under clause 442 of the DFMA to comply with section 58 of the Courts and Legal Services Act, so that that regulatory requirement was complied with. And then at 16, prior to accepting a claim, or certainly prior to positively acting for a client, by commencing and progressing a claim and using the disbursement facilities, it's alleged that Barrington would, or at least should, take the following steps. He sets out those steps: attend the lay clients to verify the information, conduct an assessment of merit before accepting, not to assess merits unless the prospects were good in the sense of 51 or 55%, ensure that disbursement funding loans were intended for the personal use of the lay client, and ensure that the CFA be entered into properly. He goes on effectively to accept that those obligations were owed. He sets out then the terms of the CFMA at paragraphs 19 through to 23, and then he analyses the claims themselves. It's important, my Lord, to observe here that the learned judge was effectively looking at the duties owed by Barrington to the lay clients, which derive from the clause, which are owed, and therefore owed to impact, under clause 6.1 and 12.1. So he is identifying the duties that were owed to the lay client in order then to assess what the liability was under the DFMA. And I've already made this submission, but I'm going to make it again. There is, I submit, an exact correlation between the position of impact. It is not unlike being subrogated to the position of the lay client when one reads his judgment and sees how he has established the liability arises. Paragraphs 33 to 45, he assesses, by reference to 4 sample cases and out of a total of 170 odd, where the breaches of duty arose. And in each case, he concludes that there was a failure to assess the merits at the outset, so that there was a breach of duty to their lay client, which led to the lay client being committed to the various obligations. It is, from Impact's perspective, very important that we should understand that the learned judge was analysing this by reference to the duties owed to the lay client. My lord, that's a long way then of my getting to the DFMA itself. If we turn to forgive me for a moment, page 140, I'm just going to go through the DFMA itself. My overall point is this: it is not a contract for the supply of goods or services by Impact to the solicitor.
Is recital A an accurate description of Impact's role in the scheme?
It's not entirely, my lord. It facilitates. A company called Impact IT provided veracity under a separate agreement. There was a supply of services agreement between Impact IT and the solicitors.
I wondered about that because there was a mention of a connected company.
Yes.
Yes.
So it's in overall terms, there has been a facilitation, but the actual service, which is separately paid for, is under a service agreement between Impact IT and Barrington.
What does that provide, Impact IT to Barrington?
So that provides the veracity service, the link-up service, which connects the claims management companies to Barrington.
So if one said IFSL through Impact IT facilitates, that would be accurate.
Well, my lord, yes. The reason why I'm anxious to make the distinction is this, that eventually I'm going to get to the point that the liability under the DFMA viewed against the exclusion is a liability that is not arising under a service agreement. If there was a service agreement here between Impact IT and Barrington, that is a separate agreement, the liability arises under the DFMA. And the DFMA is not an agreement for the provision of services. As I say, one categorises it, in my submission, as an agreement for which regulates the party's conduct. Now, I accept that there is language within it, which one sometimes finds in contracts for the provision of services. But if I can pick up on the administration fee first of all, the administration fee is a sum payable in respect of the drawing up of the credit agreement. Earlier in discussion, it was being suggested effectively as third-party consideration. It's a small amount.
It's a substantive provision that provides for the administration fee. I see it in the definitions.
Yes, my lord.
2.2.
Thank you. 2.2. The fee, I understand, is £80. And
80,000.
80.
80,000.
£80 out of the 3,500.
So the administration fee is for drawing up the loan, the credit agreement.
Yes.
So why isn't that?
Where do we get that from?
You don't, but my lord, that is. If you look at administration fee definition on page 140, right, in respect of each credit agreement, it's the administration of the credit agreement.
So that's under a credit agreement under 2.1, a credit facility.
Yes.
Actually drawn up to clients selected by the firm in its discretion, without any obligation of IFSL to make advances totaling such sum at all. But IFSL must be under an obligation to consider clients bona fide, mustn't it?
It is under no obligation to provide loans, my lord. No.
No, but it must be. There must be some. It couldn't just say. It would be in breach of the agreement if it said we're not going to consider this proposal at all.
Well, my lord, 2.1, without any obligation of IFSL to make advances totaling such sum or at all.
Yes, but it says shall offer credit facilities to clients. Could it just say we're not going to consider offering credit facilities?
Well, my lord, it can offer credit facilities, but it needn't make any. But my lord, this is one of those cases where it can offer the facilities, but it need not make any loans.
Yeah.
Well, what's the what's the difference between offering a credit facility and making a loan?
Well, it has reserved a fund of a total of £1.1 million, but it needn't make a loan under those facilities.
But the facility is itself a service, isn't it? Moreover, there are the various undertakings.
Facility means advance of credit, so facility means loan. So you can't offer a loan without making a loan.
My Lord, well, with no obligation to make it, my Lord, there can't be an obligation to make.
Well, if you offer a loan and it's accepted, what happens?
The client has accepted a loan under a Consumer Credit Act agreement, and yes, I accept that that is a service, but it's a service to the client to enable him to bring his
Well,
claim.
it's a service to both, isn't it? I mean, I just wonder whether it is right to carve up the notion in, for example, recital A. This is actually referring to the overall arrangement, isn't it? There may be other interlinked agreements which deal with other aspects of the arrangement, but this is essentially the overall agreement, which is an agreement to make available credit
Yes.
and to perform the undertakings at Clause 5. Now, those are services, aren't they? And as the recital in A suggests, their value to the solicitors who pay a fee lies in the increase in their client base. And when you refer to the fee being for drawing up the credit agreement, it doesn't actually say that, does it? What it says is that it's a fee in respect of each credit agreement.
Well,
all that means is that you get as many fees as you get credit agreements.
There's a fee of £80 for each credit agreement, my Lord, yes. My Lord, I accept that there is a facility being provided, that this agreement regulates the basis upon which that facility is being provided to the lay clients. The question is this a contract for the provision of services to the solicitors in circumstances where its overall purpose and intent is to set up a facility which clients have at their disposal so they can enter into Consumer Credit Act agreement loans, which both protects them and enables them to bring their claims, and which facilitates, I accept, that the solicitors will have clients who have funding to discharge their disbursement obligations. But, my Lord, it is not a contract for the supply of services to the solicitors. There are aspects of it which clearly provide a benefit to the solicitor. I've always accepted that. But the contract which would supply services to the solicitors might be, for example, the making of a loan agreement with the solicitors to enable them to have a fund to discharge their obligations. It's not such an agreement.
It's got to be a direct benefit to the solicitors.
Well, my Lord, it has to be an agreement for services to the solicitors.
What were the solicitors paying for?
For the administration fee, £80 for the drawing up of the effectively, it is the cost of drawing up the consumer credit agreement.
Well, that's not what the agreement actually says. It says it's just in respect of each agreement, which means you get a fee for each agreement.
Yes, it's an administration fee, my Lord.
I mean, the consideration consists of the administration fee and the liability assumed at Clause 7.2, doesn't it?
Well, my Lord, the liabilities assumed by the solicitors are 7.2, yes, is one liability, but you have 6.1 and 12.1. The 7.2 liability is, in fact, rendered necessary because if this scheme works appropriately, clients will not default, as I've indicated. So the 6.1 liability undertaking and the 12.1 undertakings are undertakings which are central to the contract, I submit, and which regulate the conduct of each party in the provision of their services to the person they're all
Why do you say
services
that the
to the lay
client wouldn't default if the thing was properly carried out? You can suppose that you assess the prospects at more than 55%.
Yes.
But the case is nevertheless lost. We all have this distressing experience.
No,
from time
you,
to
you
time.
don't. You may not, my lord, because the insurers would then pay.
Yes, I saw. Of course.
So it is absolutely central to this that the undertakings in 6 and 12 are provisions which ensure that the solicitors will discharge their professional obligations. May I just take a few moments over each of those? I know the court has been through them before. We need to start, in fact, at 4. The undertakings by the firm at 4 include at 4.2 not to permit my clients to approve a conditional fee agreement and not to undertake any amendments to the agreement without prior written consent of my clients. And that is essential, because if the solicitors do not enter into enforceable CFAs, they will not be able to recover the costs in the client's interest, and they will not, arguably, be complying with their obligations to the lay client. We move through to 6. 6.1 imports all regulatory and other such obligations, including under the Code of Conduct. 6.4 requires professional indemnity cover, which is accords with a regulatory, an agreement as I categorize it. In other words, the solicitors must carry professional insurance, as must my clients. 6.6, the regulatory obligation to maintain all licenses in force so that the solicitors are compliant. You've seen 7.1 and 7.2.
You've passed over 5. Do you want to say anything about it?
Yes, my lord. It's that if an introducer is not complying with the solicitor's introduction and referral code, then there may be non-compliance by the solicitor with his obligations. The introductions, under the solicitor's introduction and referral code, a solicitor has to ensure that anybody doing introducing is complying with the code. So it's an obligation which arises on the part of anybody introducing.
Do you want to say anything more specifically about the undertaking given by Impact in the context of whether this is an agreement under which a service is provided?
Yes, my lord. That's not the provision of a service. That is an undertaking that any introducer who does provide leads will be complying, because for the reasons I've given, my lord. I accept it. I think what my lord has in mind isn't this as an undertaking to supply introductions and referrals. No, it's not.
Right.
But it is a regulatory obligation.
Right.
Then at 6, I've dealt with. 7, I'm taking as read. Can we go to 11? There's a requirement to permit the IFSL, not unlike an insurer, to inspect the firm's records in order to check that there is compliance with the firm's duties. And then 12, you have at 12.1 that the services will be provided to the firm, by the firm to the customer in accordance with their agreement with the customer as set out in the relevant CFA. 12.2, full details of costs and services will be provided. That's again necessary to comply with the conditional fee agreement regulations. 12.3, that insurance products will be recommended in compliance with the solicitor's duties. And 12.4, indemnification, as we've heard, for negligence or breach of duty. Can we turn, before we do, 17.2, there's an entire agreement clause. It's worth pointing out because the liability that arises under the obligations owed under this agreement.
It's an agreement, is it not, between the solicitors and Impact as principal to principal, and no client is a party to it?
Forgive me, my lord, I didn't follow that.
Principal to principal.
It's principal to principal, isn't it? Barrington to Impact.
I'm so sorry, my lord.
This is not an agreement entered into by Barrington in an agency capacity. This is principal to principal. 1710 is emphatic. The only benefit by the agreement is
correct, my lord. Yes,
that
I'm so sorry.
party, and there's a specific provision in 2.3 that the administration fee is not to be charged on by the solicitor to its client.
Correct, my lord. There's a reason for that, which is that one can't charge on to the client through as a disbursement a fee which might affect the charge for credit and therefore put the CCA at risk of being unenforceable under the Consumer Credit Act. Now, my lord, I had paused at 12.1 because there was discussion earlier about the importing of the conditional fee agreement. And in particular, my lord, Lord Toulson was asking both me and Mr. Cannon as to what the differences were between the liability to Impact and the liability to the lay clients. I submit, although I don't submit this is actually relevant for the purposes of the clause 1.1 insuring obligation, but I submit that Impact is in exactly the same position as the lay client. The obligation under 12.1 is that the solicitor will comply with the duties under the CFA. If we turn through to page, forgive me for a moment, we've got the CFA in various places, to page 325. No, I'm so sorry, Madam. Page 315 and EB page 320.
Yes.
The responsibilities of the solicitor under the Law Society standard terms which are incorporated into each CFA, are at 315. We must always act in your best interests, subject to our duty to the court, explain to you the risks and benefits of taking legal action. That wasn't done. Give you our best advice about whether to accept any offer of settlement, give you the best information possible about the likely costs of your claim for damages. Your responsibilities, you must. Now, my lord, I'm pausing here because Mr. Cannon's point is a bad one, that the client, about contributory negligence. If a client is in breach of his responsibilities under the CFA, then my clients would not be able to recover as against Barrington because they would not have been in breach of the CFA.
Well, that's a different point. Contributory negligence doesn't mean that you're not in breach. You're talking about a situation where there's a defence. But contributory negligence is as I see it at the moment, personal bar pro tanto.
Well, my lord,
by the client. And how do you apply the client's negligence to, or contributory negligence to reduce any claim which you have?
But my lord, if one looks at what the duties are.
Yes. Obviously, if it read, if clause 12.1 had said, the firm's liability to IFSL should mirror any liability which the firm had to its clients, then all of page 315 would be incorporated and relevant. It doesn't. It's a warranty that you will provide any services, that the Barringtons will provide any services to the client in accordance with their agreement with the client.
My lord, yes.
It doesn't say refer to the client's duties to Barringtons.
Well, my lord, if Barringtons have complied, can I just take the point of the client misleading because he said I was, or forgetting. I've become deaf in 2006. In fact, he complained of deafness, and it turns out to his doctor in 2001. Yes, I accept that in those circumstances, Barrington may have properly incurred a doctor's fee in order to find out that the client's case had no merits, but they would then be bound to discontinue so as not to continue with the case. They would be bound to say to the client, you must cooperate with us. The client couldn't instruct them to continue, the example that came earlier. And if one looks at the duties under 315, Barrington would defend a claim brought by my clients by saying, we have discharged our duties under the CFA. We did not have an obligation to continue with the case, where a client, to use an earlier example, had said, you must, despite the lack of merits. There is no such obligation. We are therefore not in breach if you have not recovered your loan. So, my lord, one has to appreciate that this is much more nuanced.
Yeah, but take this very case, though, where it said that there wasn't a sufficient investigation by Barrington's of the merits of the client's claim.
Yes.
Now, that may in part have been the client's fault, because the clients may not have given them wholly accurate or full answers. But the reason they may not have done may have been substantially due to Barrington's failure to press them, to follow up an initial query.
That was the judge's finding.
Yes, right. Well, that's the judge's finding. In that situation, they're both at fault for the fact that the claim has been pursued, aren't they? And the fault of the client might reduce the client's claim against Barrington's, but would it reduce your claim against Barrington?
Well, my lord, I'd find it difficult to advance a claim in circumstances where it was being said that he deliberately misled us, because that would not be a breach of duty under the CFA, or he hadn't cooperated. My lord, I accept there may be circumstances where you can have a difference arising between the two claims, but it's unlikely. It's very unlikely.
We're still on contract for services.
We are, my lord.
Well, at some point you'll
Yes.
tell me how all this actually relates to the words of the contract. I mean, as I understand your case, it is that the substance of this arrangement was the provision of services to the client, not to Barrington.
Yes.
The benefit to Barrington was incidental. I mean, they got a benefit.
They also got a benefit, yes.
I mean, is that the point? Or?
Yes, that's the point.
But how does all this matter as whether who can sue what?
My lord, as a matter of fact, it doesn't matter at all, because the loss is still an insured loss, and if this isn't a service agreement, it is not excluded.
Yes, you only get into this if you were to lose the point about it being a service agreement.
Well, my lord, because there has been, I'm getting into it because of the debate during the course of today as to whether there is an exact correlation between the two.
Sure.
I'm very anxious to point out that my clients, to all intents and purposes, there may be some nuanced differences, are effectively standing in the shoes of the lay client when making these claims against Barrington.
Right. Well, we've got this.
You did say earlier, it's equivalent to subrogation, and I underlined
Similar,
it.
yes, my lord.
Similar to, and I legally, how is this a sort of case of quasi-subrogation?
It isn't subrogation, my lord,
No.
legally. It is. That's why I say, if I said equivalent to, I was wrong. It's similar to. Similar to.
But
Something that
not
has a similar effect.
Yes, you said that it was impact situation not unlike being subrogated that of the client.
Yes.
That,
Well, I'm relieved.
I
that
thought,
didn't say the same.
that needs a bit of unpacking.
It's more like Johnson and Gore Wood. It's more like derivative loss, isn't it? It's a sort of a secondary parallel.
Yes, my
world
lord,
of loss.
if I may say so, that almost exactly encapsulated. It is a loss which is parenthetical upon the obligations owed to the client.
Yes.
Your lordship is that I accept is an appropriate way to put it. My lord, I know Lord Carnworth would like me to finish the point as to whether this is an agreement for services.
does seem to be what the case is probably about.
It is, my lord, yes. And one diversion with very interesting side or subsidiary points is often not helpful.
Right, well, why, I think the point made against you is this can be a contract for the supply to or use by any insured of services. I suppose you might say in answer to that it's maybe in contract in respect of them, but for suggests you've got to find a promise to supply services, and you say there isn't a promise.
I say there's no quid pro quo.
The most there is, I suppose you can say, is a sort of if contract, a unilateral contract. And if one took recital A into account, that would be if you introduce clients which we accept and make advances to. But if you ignore recital A, then you just look at, I suppose, clause 2, if you provide credit facilities to our clients and thereby put us in funds to cover past and in advance future disbursements, then we will pay your administration fee. So you say...
Is that what you're saying?
Is that what you're
Yes.
saying?
Yes.
It is.
It is undoubtedly something that facilitates the provision of loans to clients and ensures the proper standard of service, or should have ensured the proper standard of service by Barrington's and indeed by my clients.
This is not a promissory contract as regards impact.
No, it's not a contract
Except as
for the
regards-
provision of services by impact to the solicitors. There are undoubtedly services swirling around.
But it is-
But it doesn't give the quid pro quo.
There is an obligation, is there not, on the part of Impact what they have done is to provide a facility. I mean that in the same sense in which a bank may agree an overdraft facility. It's not an if contract because there's a binding obligation to accept drawings on the account.
Yes,
And that is very similar to the arrangement that's being made here.
but here is the point. The facility, in my lord's example, is to the client of the solicitor, not to the solicitor.
Well-
So that the service, I'm so sorry.
Are we talking about the same facility? Because the facility I'm talking about is the promise that Impact make to the solicitors when they say to them, we will always have available to you this amount of credit for your clients. Now that's a promise made to the solicitors, and it's in their interest as well as that of the client.
It is in their interest, and it is a promise.
It's a facility.
Then one says, to whom is the service being provided?
Yes.
And the service is being provided to the lay client, and we're back to my repeating a submission.
But I mean, we've also got to look at the context. I mean, I think this is what Lord Justice Longmore was going to, when you were talking about a thing headed, as it is, goods and services, supply of goods and services. One's talking about, one has a sort of idea what
Yes.
that means, and one's looking at the substance of the thing, and the
Yes.
substance here is you're providing finance to the client.
That's right.
And obviously there's incidental benefit to
Yes.
Barringtons because they get their extra business.
there are
Yes.
And it's,
services.
they have a contractual right to that. But whether that's the sort of service that this clause is talking about is another.
Isn't there more than an incidental benefit in terms of business? There is actually a huge benefit in terms of Barringtons that once a credit facility is granted, they have a right to recover any disbursements liabilities they've incurred, and they have a right to have those disbursements liabilities paid as directed by them under clause 3.1, and they have the right to have the rest put into their client account, so they're secured. I mean, I agree that that is a provision of an advance under the loan agreement, but it's also a huge advantage to Barrington.
It is an advantage, my lord.
Yes. But why isn't that a service to them?
Because, my lord, when one analyses what is going on, the first factual point I ought to make is that in all of the cases that you see listed by His Honour Judge Waxman, the loan is being drawn down prior to, and disbursements are then made. In other words, the client is being committed to the loan without there being evidence that he is referring to of there being a prior disbursement. And now the reason for that is that these are conditional fee agreement cases. The solicitor cannot incur a liability for a disbursement that isn't a liability of the client,
Yeah.
because he will not be able to recover it in the inter partes provision for the recovery of costs later. So a solicitor can only incur disbursements on behalf of the client. Yes, it is the case that the solicitor will then have funds in his client account to discharge the disbursement requirements, but those are obligations primarily owed by the client, and it is the client who's putting the solicitor in funds to do so as a result of impact lending to the client. And therefore the correct analysis is that although the solicitor has these rights and he can draw on the fund, he has that right against his client to draw on the fund that he has in the client account to pay disbursements. That is something he's doing on behalf of the client. If I can...
There are not two distinct services here. One is the promise to make available the credit, and the other is the actual provision of the credit. The promise to make available the credit is not a promise to the client, directly or indirectly. It's a promise to the solicitors. We will have this amount of credit available for your clients. Now, that's a distinct promise from the one that comes into being when the money is actually advanced to that client. That's where the service comes in.
Well, there is a promise heavily subject to the fact that, yes, there's a facility, but there is no guarantee of loans. The second point is this, that what my learned friend is arguing for is that the service is occurring at the point when each loan is drawn down. Now, the problem with that is that the learned judge found that the provision of the loans is not the provision of the service, and it has not been suggested by my learned friend that the mere provision of the facility converts this agreement or makes this agreement into a contract for the provision of services by impact to Barrington. My Lord, there is a feature that the facility will be available. There is no obligation to make an individual loan. And hitherto it has been said by Mr. Cannon against me that the service for the solicitor is the drawing of the loan because that enables him to pay the disbursements. But the problem with that is that is a service to the lay client. And it draws us back to the point, how viewed as a whole do you categorize the DFMA? And the answer is, yes, there are aspects to it, which is, my Lord Sumption says, have the features of the provision of a facility, but it is not a contract for the provision of services by impact to the solicitors.
Now, it may be a bit unfair, but can I just ask you about little 3? I hope it isn't unfair.
My Lord, can you tell me which page you're on?
217. I was just looking at the clause. You can take it, if you like, on 238, which is the standard terms.
Yes.
If we look at it's little c there rather than little 3, we are at least entitled to look at this in construing the whole of the clause. Why wouldn't this type of situation be within the concept of undertaking by the insured in connection with the provision of assistance or other benefit or advantage to the insured?
Well, my Lord, here, my bull point is that the provision of the benefit is the provision of a benefit to the lay client. Yes, there are...
but you said a moment ago that Clause 3 was, for example, a huge advantage to Barrington's, or I think you thought you accepted when I put it to you, but you said it wasn't a service. But if it's a huge advantage, it's surely a benefit or an advantage.
Well, if it is, my Lord, it would have to fall within the indirectly to the insured. It's not a direct advantage to Barrington, and the real advantage is to the lay client.
I don't know. Funding is and not having to whistle for the money is probably, I think, the essence of this sort of deal, isn't it? they needed their disbursements funded at the outset, or the show would never get on the road.
Are we using 3 to say, for what purpose? I'm not quite sure, because we're not under 3.
We're not under
We're
three.
not under three.
I mean,
but we're-
arguably, the fact that 3 talks generally about benefits and advantages suggests that goods or services is something rather more specific,
It does.
which would help.
The way that we would submit 3 is in broader terms, in the sense that, as my Lord has pointed out, it is a guarantee, indemnity or undertaking by any insured, a Barrington, in connection with the provision of finance, property assistance, or other benefit, directly or indirectly to that insured. That language in those terms is wider than one sees under 2, which is breach of the terms of a contract or arrangement for the supply to or use by the insured of goods or services, not directly or indirectly. And it is breach of the terms of the contract. The breach which we rely upon is a breach of the DFMA. It therefore has to be established that the DFMA can be categorised squarely, I submit, because it's an exclusion clause, as a contract for the provision of services.
Clearly, we're here speaking about a contract, but what is B talking about when it also covers an arrangement?
My Lord, it's difficult to say, I accept. But how can you have a breach of an arrangement?
But that's what I was wondering.
Yes, and my Lord, I'm afraid I stand, it's an awkward, the language is very awkward. There might be arrangements which give rise to particular obligations which are short of contract, but which, for example, fiduciary obligations and so on.
There might be expectations.
There need to be a breach of
Well, an arrangement for a contract for the supply, as I was suggesting earlier, suggests a promissory,
Yes.
a promise that there will be a supply. Maybe an arrangement for the supply is a contract which governs a supply if made, but doesn't actually promise that the supply will be made.
The problem, my Lord, is this, that you have to have a breach. We are construing an exclusion clause, and I know I shouldn't be labouring the strict construction point, but this is predicated by breach by the insured of the terms of any arrangement. So the breach which I rely upon is a contractual breach.
It would be a breach of an arrangement in respect of the supply. That was what I was suggesting.
Yes, my Lord, it would be odd to have a breach of a contractual duty and then say, oh, but by the way, under the disjunctive part, or you have a breach of an arrangement. My Lord, this argument came up in the Court of Appeal, and effectively we went down, I think both sides went down the route of saying, well, we've got a contract here. This is an either-or provision. The breach here arises under a contract, and therefore you have to categorise the DFMA as a contract for the supply of services. It is an awkward provision.
Yes, I was just trying. I wasn't suggesting that we would call this an arrangement. I was just trying to understand what the arrangement was.
So the great joy of being in my position where I'm arguing against an exclusion clause is...
It doesn't matter.
It doesn't matter to me, but the only examples I can think of would be a breach of a duty where there is a provision of services which is a fiduciary obligation or something of that sort. But it's difficult to say how you can have a breach of something that isn't a contractual breach, and here we have a contractual breach.
Do you rely on Tectrol at all? I mean, Tectrol is in
Yes.
where I was found to be wrong, because I took too narrow a view. But you rely on that as
Yes, I do, my Lord.
For what
Yes.
purpose?
Really for the purpose of the approach to construction. My Lords, I also, with some hesitation, because in the Court of Appeal we had considerable argument about the VAT cases, and I can see one head being shaken as I speak. But it is not, frankly, worthwhile my going into the intricacies of air tours, which was before the court earlier this year. But in a VAT case, one is trying to work out if there is a supply of services, and one does that by asking, is there a contract for the supply of services from A to B, such as gives rise to an obligation to pay or an ability to offset VAT. One looks at the factual circumstance if that may dislodge the construction of the contract as a whole. My Lord Carnwath was in a minority with Lord Clark in air tours. My point in relation to air tours is this. There was not a contract for the supply of services in air tours. In circumstances where air tours was paying the whole of the fee for PwC to provide £220,000 or thereabouts, to provide a report which then went to the lending institutions, which enabled them to restructure their lending arrangements for the benefit of air tours. And the court upheld, the majority in the Court of Appeal, that was not a contract for the supply of services, and nor
It was
did...
a contract for supply of services, but not
not
to air tours.
Yes, not to air tours. Now, the comparisons I make are with this case. Here, we are not... The loan is being made directly by impact to the lay client. Yes, there's an administration fee, but that, frankly, is tiny by comparison with what was happening in air tours, where there was no contract for the supply of services as between air tours and PwC. There was an obligation owed to PwC to provide, by PwC to air tours to provide the report. That led to two members of the court, when viewing this in its factual context, or by reference to the financial circumstances, the two dissenters, my Lord Carnwath and Lord Clark, saying, well, this was a contract for supply of services, the majority saying that it wasn't. And I submit that the majority would come to the same result in this case, if one's comparing the different aspects of the agreement as they would in air tours, as would the minority. But I can leave that decision to my Lord as to whether that submission is correct, at least so far as Lord Carnwath is concerned, because we are...
You're looking at cases in which I'm dissenting.
Well, my Lord, it's best to see if one can persuade the dissenter to come round on this occasion to one's...
But I mean, for my part, I don't think the VAT context is going to help us at all.
It doesn't. I accept.
Because it's pretty unclear in itself, and to introduce that into a case which is pretty difficult is just adding a further complication for no purpose.
It's only useful to this extent. It provides some cross-check as to... It would be very odd, my Lord, in a VAT context where a supply of services is not defined by reference purely to a contract, to say in this circumstances where you have a DFMA which is not quintessentially a contract for the provision of services, to say that whereas in one case you do not have a contract for services, but in ours, you know...
Yes, I mean, personally, I'm not quite so sceptical about the VAT cases. VAT is... although there are some wrinkles, it's ultimately supposed to be based on a proper analysis of who is supplying who. And, I mean, the secret of air tours, am I in a minority here in having been in the majority there?
No, you're not.
I'm not, Lord Hodge.
I was the majority as well.
Right. Anyway, the secret of air tours is surely that... it wasn't Air Tours who asked PwC to advise the lending institutions. It was the lending institutions who asked PwC to advise them, and the lending institutions who simply imposed on Air Tours an obligation to pay PwC's fee for understandable reasons, since the lending institutions couldn't recover the VAT themselves, probably. Anyway, that's a different case, it's argued, from this one, where it said that Barringtons are up front, taking the initiative, approaching Impact, getting them on side, getting them to arrange this facility, and giving Barringtons a pretty large benefit en route. So both in terms of clients and in terms of cash in hand. So I mean, there is a difference, but I think...
I don't want to get into factual debates are often unhelpful, but the CMCs, the case management companies, the intermediaries, who were unlawfully paid by Barrington's referral fees, are the people who bring the claims to Barrington's. Yeah. They then have access to the veracity facility, which is not a contractually bound facility under the DFMA. So yes,
They bring it to Barrington's through the facility, don't they?
well, it's through the CMCs who come to the facility,
Quite,
and then yes. But the DFMA is not a contract for the provision of those services, and then we're back into the old argument.
So how much further have we got to go,
With a bit of luck, my lord, not too much more.
You indented for an hour and a half, and I think you had
Very
it.
close.
But,
My lord, I think there are two points which I need to make, and then I can sit down. I've made these in the course of questions already, but forgive me if I'm repeating myself. Can we just have a look at His Honour Judge Waxman at paragraph 49 of the coverage judgment? The EB reference is 141.
sorry, what was the page again?
EB 141.
Oh, I thought this is the coverage judgment.
It should be, and the core bundle page is
Yes.
137.
Right, I've got it. Thank you.
Paragraph 49. Before we look at this, my lord, we have to ask this question. What is the obligation that arises under the DFMA, the breach of which gives rise to the liability? The obligation is to discharge duties to the lay client. What benefit does the lay client have? The lay client has the loan. The loan is made to the lay client. It is distributed by Barrington. And my lord, the learned judge got this right. A loan might properly be described, I'm reading from the second sentence, as a kind of financial service. But it cannot be said that by the funding agreement, Impact made or agreed to make loans to Barrington. For the borrowers were the lay clients, even if Barrington agreed to guarantee repayment by them. Nor can it be said that the loan monies were for the use of Barrington in any real sense. The fact that Barrington was the conduit for the monies and distributed them for the purposes of paying disbursements and insurance premiums on behalf of the clients does not mean that the monies were for its use in any beneficial sense. That's entirely correct, and it accords with the legal analysis. He then goes on at paragraph 54, the passage that was read to my lords this morning by Mr. Cannon. But here he's dealing not with obligations that arise under the DFMA. The veracity arrangements arise through a separate company under a separate service agreement. It is not a duty on the part of Impact under the DFMA to find clients, bring them to the solicitors, or enable the solicitors to have the opportunity to enter into conditional fee agreements. Of course, they have an advantage because their clients are funded. But the error that the judge made at paragraph 54 is to equate benefits which surround this contract with duties arising under the contract, and thereby saying it's a contract for services. And there, I submit, he is wrong, and we so submit it to the Court of Appeal.
Do you disagree, do you find fault with the sentence, line 6? Impact was making available to Barrington a valuable facility at Barrington's option.
Yes. I find fault with it in this way. Impact was making a facility available, but ultimately, and Barrington is involved in the administration of the facility, yes, but it is the client who is going to be receiving the facility. The facility is the Individual Consumer Credit Act loan. There is an availability of a fund, but my lord, stripped to its essentials, it is not different from a bank lending clients monies for mortgages who go to a panel of solicitors who are then able to use their mortgages to discharge liabilities for legal expenses, or people in receipt of loans and such like. There obviously is a facility, but it is not, when analysed, that doesn't convert the DFMA into an agreement.
It comes to a very short point, doesn't it? Under 2.1 of DFMA, Impact contracted with Barrington as principal and not on behalf of anybody else to offer facilities to clients. In return for that, it was being paid money for administration fee, etc. And the question then is, well, in contracting with Barrington to offer credit facilities to Barrington's clients, was that an arrangement or agreement providing a service to Barrington? You say, no, it's no service to Barrington. The judge has said, no, commercially and realistically, it was a service to Barrington. That ultimately is the short point on which...
Well, my Lord, but remember, we are here determining whether this is a contract for services, and you view the contract as a whole. Yes, there is a facility. The services that are being provided here, that this contract is dealing with, are the services which enable clients to enter into loans. That is, if you say, what is the contract for service? Financial services is the provision of the loan to the clients. That's pretty classically the case. And a solicitor is entering into a contract for services and is bound by the Act to do so with reasonable care when he enters into the conditional fee agreement. That's a contract for the provision of services. This agreement or arrangement is not a contract for the provision of services. Yes, there are benefits, but, and then I get to my next point, only if it is squarely falling within the exception can it be categorised as a contract for services. And the reason why we're all having this difficulty is because I submit it doesn't squarely fall within the exception, and therefore the exception doesn't.
Right.
Thank you very much.
Thank you very much, Mr. Dutton. Mr. Chapman?
I have nothing to add. Thank you, my Lord.
Thank you. Yes, Mr. Cannon.
My Lord, can I look at the DFMA and just go through a couple of points which have arisen about and show how it does provide the service. It's the core bundle divider rate, page 140, or EB, page 144. Reference is made to the recital, whereas A, IFSL facilitates the presentation of PI claims to solicitors through its online claims introduction and trading services Veracity. That's a sister company or a coordinate company, and provides funding for disbursements under credit agreements in respect of those PI claims. That is Impact. From the point of view of Barrington, clients without funding are not much use. And funding without clients isn't much use either. They may have a stack of money available, but no clients. The clients come in a way, they find them by trawling through Veracity, where the claims management companies put people up. But they're no good, it's a waste of time to them unless they have funding. So, and the funding is therefore a crucial part of the service. If one then goes to the administration fee, well, first of all, it's the facility, and that tells the solicitors that they're not wasting their time when they go off and trawl through Veracity looking for clients, or potential clients, because they've got at least a reasonable expectation that if they get a client, they'll get a loan, or the client will get a loan and they'll have a funded client, which is what they need. The administration fee, clause 2.2, is payable on the execution of each credit agreement by Impact. And my little friend told your lordships that that was a fee for their administration work in drafting the Consumer Credit Act agreement. But can I take your lordships to the judgment of His Honour Judge Waxman in the underlying liability trial, divider 6, which he sets out in some detail how this was done, page 114, page 118 of the electronic bundle. It's paragraph 8 and 9. And they've gone to veracity, they've identified a client, that's paragraph 6 and 7.
Sorry, which paragraph?
Paragraph 8 and 9, the point that paragraph 8 picks up,
I think I've got the wrong page.
it's page 114 for the hard copy.
Yes, I've got the hard copy, thank you.
By the stage we get to paragraph 8, Barrington have gone to veracity and found a client and done other things. And then, if Barrington then provisionally accepted instructions to act on behalf of a client, veracity, that's the sister company, would require it to indicate whether it required impact to provide the relevant disbursement funding loan, which insurer would be required to provide the legal expenses policy, and which medical company would be used. Barrington would at the same time return which disbursements were to be funded from a default list, and that would be then calculate the value of the loan. Veracity would then automatically generate the loan agreement and send an email to the claims management company giving notice that the status of the claim had changed to accept or provisional acceptance and instruct the CMC to progress the matter. Then paragraph 9, the claims management company, as Barrington's agent, goes out and gets the form signed. So the agreement, the DFMA doesn't mention what the administration fee is for, but the detailed findings of the judge show that the one person who didn't do any administration of the CCA agreement was impact. It's all, what happens is that Barrington types in it wants funding for its client, it types in which AT insurers, you know, the premium, which medical people, so it finds out the fee, and then Veracity calculates the amount that's needed and prints off the form, which then is filled in by the CMC with the client.
Well, presumably Veracity and the CMC get paid somehow, do they?
I think there was a fee payable to access Veracity via the solicitors, and the claims management companies get paid a fee. I don't know how they get there. They're funded in some way or other.
They're funded?
Well, no, actually, technically, it's not by me. My learned friend says it's by me. He is actually standing in Barrington. He keeps claiming to be standing in the client's shoes. He is standing in Barrington's shoes. I am the insurer. So he is actually the people who paid the money away wrong. He's laughing, but it's actually true. It's about time we got that point across on the broad merits. He is the solicitor who paid the money away wrongly. I'm the insurer of that solicitor, for present purposes. He's in a better position. So what happens here is the claims management company clearly is entitled to some legitimate fee. I don't know what it is, but he may have got an illegitimate fee in these particular cases. They're not doing it for fun, for altruistic purposes. They aren't charities. They're getting some money at some point. So they go off as their agents. There is nothing here to indicate any work by impact on these loans which would justify a fee. So if it goes back to the wording of clause 2.2, at page 142 hard, 146 electronic, the firm agrees to pay the administration fee to IFSL on execution of each credit agreement. There's no indication, my learned friend has told you, but the agreement doesn't say this, that it's for IFSL's work on the drafting of the CCAs, but they are standard form documents. Veracity prints them off, sends them out, and they get signed by someone acting as agent to the solicitor. So one doesn't immediately see how that could be right. And it's very telling, we say, that the fee is payable when each loan is made, because that is when we say the service is provided to Barrington. There are all sorts of contractual obligations which may never be engaged. A contract of insurance is the classic one. I insure my house every year, and it doesn't burn down. So the obligation to indemnify me is never triggered. But the obligation is there. Some of the obligations of this contract are only triggered when certain events happen. But it's still, when they do happen, then that's governed by this contract, which is why we say it operates at different levels. And it's when. If no loans are made, then the whole contract's really a waste of time, because all these mutual regulatory duties have no purpose. What you have here is an agreement which is when it works, and at the time it was entered, there's £800,000 had already been, £680,000 had already lent under some previous agreement. What this has is, each and every time a loan is made, the obligation is on impact to pay it as directed, and the obligation is on the solicitors, Barrington, to guarantee repayment of that loan and to warrant that they'll conduct the claim with reasonable skill and care. And that comes in at that point. So that's what happens. And this fee is being paid each time a loan is made. And it is recognising that each time a loan is made, there is something, a benefit, a service provided to Barrington. Can I just deal with the VAT cases? They are incredibly fact sensitive, and as one discovers when one goes into them, the Air Tours case, and they give rise to nice differences of opinion at the highest level, if I put it that way, it appears. I was going to just draw attention to, we can all find cases in the Court of Appeal, Lady Justice Gloucester dissenting, set out a passage from another case where the Redrow Holmes.
What page should we be looking at?
Tab 6, Authorities Bundle.
Page.
And it's the case, it's a page within the report. She was dissenting, but these were general statements of principle. Anyway, she's citing from the majority decision or the House of Lords. And it's page 80, letter F, from the case of Customs and Excise, Redrow Holmes case.
So page,
80 of the text, 53 of the bundle.
yeah.
53424, I'm sorry.
Yes.
Having three numbers is quite confusing
Right.
to get through. She's citing from the Redrow Holmes case, Customs and Excise Commissioners and Redrow Group Limited, 1999 One Weekly Law Reports 408. And that was a case where Redrow Holmes, which is a housing developer, offered a deal to people who wanted to buy their houses that they would fund help them sell their houses. And they got the people who, they would pay the fees of various people helping them buy their houses. Also, and that was held by the House of Lords to benefit both to the potential purchasers and to Redrow Holmes. So you can have it to two people. These things are very fact sensitive. And that's the point. In each case, you have to look at the facts. And my Lord Carnworth would have found that there was a benefit to Air Tours, and they are very fact sensitive. And there's no principle that emerges from them which helps decide this case in my submission. We have to look at the facts of each case. And in the way my Lord Mance said that when I friend Mr. Dutton, you have to look at the facts of each case to see what those facts are. Can I then deal with subrogation standing in the shoes of Johnson Gore Wood? This idea that somehow my learned friends, as impact, is standing in the shoes of Barrington's clients.
Well, I don't think he contended that that was the strict legal analysis.
No.
I think what he was saying was that it was analogous in its results.
Yeah. In my submission, they have different claims and different interests. I've made that submission many times this morning, and they are not claiming through them in any way, but independently under Impact's own contract with Barrington. They're not claiming through the retainer. They have a warranty which gives them a right under their contract, but it's an independent claim with independent interests and independent damages. And to say, well, the damages are broadly the same is irrelevant. That happens to be this particular case, and they are still different. The client's claim, on the facts as found by His Honour Judge Waxman, would be, you expose me to a loan. I have to pay the full amount of the loan. And that, as I laboured the point this morning, that might be subject to contributory negligence or some other defence. The Impact's claim is, I made the loan, and it cost me money to fund the loan. It's a different claim. And my learned friend relied upon the CFA agreement, and I won't go back to it, deliberately misleading. Your Lordships will recall the words, the client does not deliberately mislead. They said, well, that means that if the client gets it wrong, and says, I was only deaf last year, then the client has no claim, and we have no claim, Impact, because you're not in breach of duty. But that's not right for two reasons. One, a client or potential client could negligently, or even perhaps non-negligently, be confused as to when he or she first went to the doctor about hearing troubles. So there could be a careless or even a non-careless muddling of dates. 2, it may be that the client is trying to deliberately mislead the solicitor, but the solicitor should have spotted it by probing and making the right inquiries, for example, getting the GP records. At which point you could have a situation where the solicitor who doesn't probe and find he's been deliberately misled is in breach of duty. So there is a breach of warranty under the DFMA, but the client has no claim because he is deliberately misled and there's a breach of duty back and a circular cause of action. So deliberately misleading is not a full answer to my point. Well, this comes down, as well, has become very clear, to, and as I said at the beginning, to a short point, does this contract fall within the exclusion? And we say it's accepted that a very great benefit was conferred on our client, on Barrington by the DFMA. And it enabled them to take on a repeated number of claims, each time a loan is made, with a funded client. We say that wasn't a benefit of service to them, it was a service provided to them. Now, the paradigm example, as the judge, first instance, found, of might well be the photocopying lease.
Might be what?
A photocopying lease.
Yes, quite.
That would be the bullseye on the target, but there might be other rings which are still on target within the scope of the clause, and we say they may not hit the central, the bullseye, but we're still well within the target in the scope of this clause. Well, let's take your lordship further.
Okay, thank you very much indeed. We will take time to consider our judgment and it will be handed down in the usual course. We're grateful to counsel for their succinct arguments and helpful cases.